The U.S. Supreme Court has just ended firearm permits nationwide. It finally happened. This is not a legal interpretation. This is the total collapse of the permit-based system for concealed carry across America. For every gun owner, for every concealed carrier, for every single Second Amendment supporter watching right now, the rules have changed forever. We are not talking about subtle adjustments. We are talking about 10 gun laws that just changed overnight due to a massive new Supreme Court gun ruling. These are not state changes. This is a nationwide constitutional mandate. From the complete destruction of May issue to the new constitutional standard that governs every future case, you need to know exactly how these new gun laws 2024 will impact your right to carry. The new rules start in December, and the time to understand them is right now. Let's start with the one that rewrites the map. Law 1, the total collapse of the permit requirement barrier. For over a century, the power structure used bureaucratic permits to control the right to bear arms. They forced citizens to ask for permission to exercise a right guaranteed at birth. That era is over. The Supreme Court has unequivocally declared that the Second Amendment's protection begins at the Constitution, not at a government office, and that the right to carry does not start with approval, it starts with existence. Permit requirements that impose subjective, good cause standards, excessive fees, or endless waiting periods are now constitutionally void. The system built on requiring citizens to prove their worthiness has been dismantled. This is the death of the May issue system and a direct seismic shift in national gun laws. Law 2, constitutional carry changes, go national by judicial decree. Before this monumental ruling, constitutional carry was a legislative preference in a majority of states. Now, it is a constitutional floor. The court has given permitless carry legal backing across all 50 states. This is not a state-by-state process anymore. This is a national 2A update. States can no longer require you to justify your need to carry. The subjective standard, the idea that a state official gets to decide if your life is in danger enough to exercise your right, has been struck down as unconstitutional. Every law-abiding American now claims a constitutional foundation for unlicensed carry, forcing judges to apply a single constitutional rule, not 50 different political interpretations. This ruling does not create a new right. It enforces an old one. The most critical long-term change is the adoption of a new, singular legal standard for the entire body of gun control law. Law 3, the enforcement of strict scrutiny and the THT test. The Supreme Court has solidified the strict scrutiny gun ruling first established in Bruin. The message is absolute. Any current or future gun law that burdens the right of a law-abiding citizen to bear arms must now be justified by the nation's historical tradition of firearm regulation. That is the text, history, and tradition test, or THT. Courts can no longer weigh your rights against political opinions, public polls, or emotional arguments. The age of judicial compromise is coming to an end. This is the single most important legal tool for gun rights breaking news. Moving forward, every single piece of restrictive legislation is now vulnerable to legal challenge because the burden of proof is impossibly high for the state. Law 4, the DOJ's unprecedented concession on permits. For decades, the Department of Justice fought every expansion of the Second Amendment. But something changed with this ruling. The DOJ did not oppose the decision. In fact, they quietly supported it. Federal attorneys recognized that continued defense of subjective permit systems was legally fragile, especially after Bruin. The DOJ declined to challenge the court's reasoning, signaling a massive tacit acceptance of the new constitutional standard. This is a seismic shift in government behavior. The federal government has essentially acknowledged that licensing delays and complex approval systems conflict with constitutional intent. This ruling is not just legal, it is an economic earthquake for the bureaucracy built around restriction. Law 5, the collapse of the multi-billion-dollar permit industry. Behind every permit system was an entire industry of government application fees, fingerprinting services, certification programs, and mandatory training organizations designed to profit from a constitutional right. That industry is now crumbling. For decades, Permits generated billions in revenue. That stream is about to dry up. Permit application and renewal fees are already being canceled in numerous states. State-run databases tracking licensed carriers are losing their legal foundation. The system built on collecting fees for rights is collapsing under its own weight, replaced by true, unlicensed freedom protected by law. Law 6, local ordinances and sheriff discretion are immediately voided. Law enforcement is caught in the middle. Across the country, sheriffs and state attorneys are being forced to choose between enforcing old, unconstitutional statutes and complying with the new standard. Attorneys general in several Pro-2A states have issued statewide guidance declaring all local permit rules and restrictive county ordinances void under the new national standard. Sheriffs in counties across Georgia, Idaho, and Arizona have publicly declared that permit checks are over. Any attempt to enforce a local regulation that requires a permit or uses subjective judgment to restrict carry is now exposed to immediate and devastating civil lawsuits. This is the power of the Supreme Court gun ruling being felt on Main Street. We must be authoritative and clear. This freedom is not absolute, and there are two critical limitations that every gun owner must know about. Law 7, the upholding of federal ghost gun restrictions. While the Supreme Court has dramatically expanded carry rights, it also recently weighed in on the issue of unregulated firearms. In March, the U.S. Supreme Court upheld federal restrictions on ghost guns. Specifically, the ATF's rule that treats certain unserialized firearm parts kits as complete firearms. This is crucial because it shows the limits of the THT test. The court's decision, while frustrating to some, allows the federal government to regulate kits that are readily convertible into functional firearms. This prevents the argument that the Second Amendment somehow protects an entirely unregulated shadow market. The ATF updates are still a factor, and this specific ruling proves that. Law 8, SCOTUS declines to hear other gun control challenges. In a separate move, the Supreme Court has demonstrated its commitment to the new Bruin standard by declining to hear several other gun control challenges. This might seem counterintuitive, but it is a powerful strategic move. By refusing to take up cases that could potentially force the court to apply the new THT test in a way that could be misinterpreted or lead to a weaker ruling, the court is allowing lower federal courts to solidify the precedent first. They are protecting the integrity of the permit ruling and the strict scrutiny gun ruling. They are sending a signal: the foundation is set, and it is not open for debate right now. The reaction from states that built their entire gun control framework on the idea of discretion has been immediate and frantic. Law 9. The legal fight over sensitive places, expansions. Blue states like California, New York, and Illinois know they can no longer mandate permits, so they are pivoting. Their entire strategy is now focused on creating massive, sweeping, geographically defined, sensitive places to prohibit concealed carry. They are introducing new gun laws that redefine entire cities, public transportation, and even private businesses as areas where your Second Amendment rights simply do not apply. This is the new battlefield for concealed carry changes. These new laws are simply permit requirements under a different name, and they will all immediately face massive legal challenges that will test the boundaries of the THT test. Law 10. The constitutional turning point. Rights at birth, not by approval. Finally, the 10th law that is changed is a conceptual one, the fundamental legal definition of a right. The latest Supreme Court gun ruling is the final piece in a chain that started with Heller in 2008 and continued with McDonald in 2010. It declares that rights do not begin after approval. They exist at birth. This is a generational moment. The court has not just restored the Second Amendment, it has reminded America how constitutional law is supposed to work, by protecting rights, not merely managing them. The balance of power now favors the citizen, not the bureaucracy. This is the definitive Second Amendment news of our lifetime. The line has been drawn. Permits are fading into history, and freedom is reclaiming its place at the center of American life. But understanding this ruling is just the first step. The real fight is in ensuring that the states comply and that these new laws are enforced. The challenges over sensitive places, the continued resistance from gun control groups, and the necessary ATF updates, all of it demands your constant vigilance. You must know your rights because, as we have detailed, the new rules start in December. If you believe in facts over fear and you want real, clear, authoritative updates on the rulings that shape your rights, make sure you are subscribed and hit that notification bell. The next wave of decisions and legal battles is coming soon, and we here at US Armed Updates will be here to break every one of them down clearly, accurately, and without the noise. Stay alert, stay informed, and above all, stay free.